Hello, good afternoon, everybody, and I apologize. I'm sorry I wasn't here with you for the first two sessions. If we haven't met before, my name is Hisham Abdurrahman, Muhammad Abdurrahman Fadlur Rahmatullah Abdullah. That's the full name, but most people know me as Hisham, and you can call me as such. Most of you we have already met in our previous courses through the STEM involvement in the labor migration diploma. For those who don't know me, I am one of the course coordinators here at the Labor Migration Cluster at the ITC-ILO. I work closely with Hakeem, as you already know him very well, with Miriam. And today we have the pleasure of having Amanda Mejia Cañadas here with us for our third session of the Labor Migration Academy, dealing with adopting a right-based approach to labor migration. More specifically, to be guiding us through the ILO instruments on protecting migrant workers. Today's session will be dealing with that. Before we jump into that, I just wanted to touch base with some of you and let you know that you probably received some emails from myself or from ITC ILO Sam email asking you to send us your passports if you haven't sent them already, because we have to finalize your itinerary to travel to Johannesburg, and it's not very far from now. It's less than 2 weeks. So if you haven't done so, please send us your passport. And if you're already receiving your itinerary, if you haven't received it yet, you receive it by today or tomorrow, and you can confirm your preferred itinerary, and we'll take it from there. And if you have any questions, as always, you can write us an email, or you can even ask me some questions at the end of the session. I will stay behind after the session. If you have some direct questions you would like to answer, I'd be happy to answer them in that regard. Having said that, and before, I think now we can give the floor back to Amanda Mejia Cañadas. She's the International Labor Specialist and International Labor Law Specialist out of Pretoria office, a part of the ILO Decent Work team for Eastern and Southern Africa. And I would let Amanda introduce herself, but I'm pretty sure most of you already know her being from the region. But Amanda, the floor is yours.
Thank you very much, Hisham. I'm always very jealous of Arabic speakers because they're the only one who managed to pronounce Spanish properly. And you can pass as natives. So good afternoon, everyone. I'm very happy to see some familiar names. As Hisham indicated, my name is Amanda Mejia. I'm the International Labor Standards Specialist. I have the pleasure and the honor of servicing 18 member states in Eastern and Southern Africa, including 14 out of the 16 SADC member states. So the advantage is that we can be looking at this topic from the SADC perspective, given that there is an upcoming meeting of the JTTC. So it's a pleasure to be with you today. I will be speaking in French during my presentation, but feel free to ask questions in English or French. I may stutter in both. Thank you.
So Amanda will be sharing her screen, the presentation in French. As always, if you would like to follow the presentation in English, just go to the view options on top of your screen and select the other option, which I will be sharing. So select Hisham Abdulrahman to see the presentation in English.
Thank you. Can you all see the presentation? I'm going to remove my video because my internet has not been as good as it ought to be. Can you see the presentation online?
We can see the presentation, but if you can give me just 1 second, I'm trying to present it in English on the other side. And at the moment, I'm not able to.
Hisham, I can confirm that I see her presentation correctly.
Yes, but I don't have the option of presenting the second one right now. I need to change the settings of the Zoom.
Ah,
Well, maybe Isham, just the time that you achieved to adjust the setup. May I just, for a moment, just I will, Amanda, stop sharing your presentation.
okay.
I think you can put your video on again. So just a little bit also of recap of what we have seen since last week. We were with Theo, and that's also for you, Amanda, interesting to know. So we were reviewing a little bit, you know, some of the key trends on labor migration at the global level, sorry, but also at the specific regional level. And it's what's quite interesting. And I think, you know, the discussion on the rights-based approach is coming at the right moment, because obviously there was a lot of discussion looking at the trends on the question to what extent certain specific groups of workers, migrant workers, have more likely access also to certain protected job comparing to other. And I think this session is obviously to look at the international instrument existing to protect migrant workers, but it's also, and this is something, a reflection we hope you can keep throughout the whole academy, because again, the ILO approach on migration is a rights-based approach, and it's very much ensuring that while developing even a policy, it has to be grounded on international standard, minimum standard that I would say below this standard, any policy shouldn't happen. So a rights-based approach is ensuring that obviously the rights of the migrant are the center of your policy, but it's ensuring that any legislation taken is grounded on international standard. And with Amanda, you will see that these standards are only providing minimum standards. So nothing, neither forbidding the countries to go beyond what is in this standard. And we will see that indeed there are some specific standards protecting migrant workers. But then I think this is what is, I would say, the most encouraging. We see that certain new countries are also ratifying this standard, which is already a good sign. But if not ratified, there are a lot of other standards that can be particularly relevant while trying, you know, to promote the protection of migrant workers. And this, I think, is in a way the kind of important message as well. It's not only about international standard protecting migrant workers as such and covering the questions related to governance of migration or the rights of migrant workers, but it's any standard, whether, and then today we will focus on the labor standard, but any standard that can be very relevant, useful, while trying to promote the protection of their rights and the agenda on the better protection for migrant workers. Isham, I'm asking you, is everything set on your side? It is. So Amanda, without further ado, I think you can maybe take the mic on. Just interpreters telling me that on your side, the sound is very low. So just make sure that you're speaking very, you know, very well in the mic during the session. So I think they were a little bit struggling to hear you well.
Can you see my screen?
We do. Yes, Amanda, we saw it very well.
Excellent. I was going to make the joke that I'm a very soft-spoken woman, but then I realized that most of you know me already. And I can't fool you. Okay. Donc, merci beaucoup à toutes et à tous.
So thank you very much. I would like to take the floor now and speak English, and we have many friends from the SADC region, and I would like to show you two tables on ratifications by country and by standard. These tables concern SADC countries, and this will be a chance for you to have a clearer vision of what happens in your countries on this side. So what we would like to do today is to touch upon some questions. Why do migrant workers need specific protection? We will talk about this right-based approach to labor migration, and then international labor standards and the ILO mandate, and the applicable ILS, and specifically the ILO migrant workers instruments. We will talk about a couple of conventions and a couple of recommendations that are about these specific matters, and then we will talk about ratification and implementation of such instruments. And if we have time, we'll talk about other, so complementary ILO frameworks and guidance and other relevant international frameworks. So the idea for this presentation is also to give some space and room for participants to interact and to ask questions. Why do migrant workers need specific protection? Because in general, the non-nationals in another country need to be protected because they are more vulnerable to direct or indirect discrimination in law or in practice. We also have to consider the fact that labor markets can be challenging, not only for non-nationals, but also for nationals. So the pressure of the market can be particularly heavy on everyone, and especially on migrant workers. Obviously, we have exceptions, and we all have in mind some specific kinds and categories of migrant workers, just like, for example, those working in the oil sector or in telecommunication sector. But migrant workers are usually employed in precarious employments and sector and less protected sectors and employments. So we're talking about several sectors, such as agriculture, construction, domestic work, and manufacturing. So such sectors, depending on the country, so on our country of origin, we have an idea of the typical profile of the worker in such sectors. I can think about some of your countries that have a kind of strong manufacturing sector and export sector, and in your countries, a great majority of the workforce is women. So such workers are more exposed to challenges and violations. So the decision to emigrate isn't always a clear and informed decision. Many times, and very often, it's a kind of obligation because of crime, because of the need to find a job and to earn some money, or for many other reasons. Poverty, climate change, there are many circumstances that can push workers to emigrate. And the level of skills can expose them to more challenges, but it's not only that, it's the where they work and the sector they work and the specific position they have. So we also have to consider. Amanda, we're still on slide 2. Is it right? I'm on 3, page 3. There we see number 2. Here we go. This is number 3 now. So it was not in sync. Thank you for telling me. So these people are exposed, as I said, to multiple and intersectional forms of discrimination. I know SADC countries, and SADC countries declared the ILO Convention Against Discrimination as a priority convention. So when we talk about multiple discrimination, we're talking about a person having many characteristics that can be the object of discrimination. And the motives are clear and clearly detectable. In the case of intersectional discrimination, there are multiple motives for discrimination. But let me give you an example, a very common example in Europe, maybe a less common example in your latitudes. When you talk about visible religious signs, so in general, we're talking about one specific religious sign. And it's the example of the Islam and that religion. So we're talking about the chador or the hijab. So we're talking about one specific religion and one specific gender. So these clothes are used by women. So this is an intersectional discrimination because it's a discrimination that is linked to the sex or gender. Or both. But it's also a discrimination that is based on religion and a discrimination that is based on the association to a foreign nationality. So it's very difficult to understand what's the motive of discrimination for this case of intersectional discrimination. So migrant workers are exposed to such discrimination. And there are also more risks of exploitation if they are in an irregular situation. Why? Because a migrant person in an irregular situation, when the country penalizes and criminalizes such status, this person will be even more exposed to exploitation because of the lack of access to justice. Why do we need such a right-based approach for migrant workers? Because they are human beings, as we are. We all are. And another point that we will consider in the framework of the convention is that international labor migration should not be exempt from application of rule of law. So these people are exposed to the violation of their working rights, but also of their human rights. So we need minimum standards, and ILS can be the basis and the ground for the formulation of migration policies at national and regional level. There are countries that have recently adopted a migration policy in a tripartite manner with the technical assistance of some projects. There are other countries that are about implementing it.
Un suivi indépendant et transparent est nécessaire pour garantir le respect de la législation et favoriser l'amélioration des cadres.
A follow-up is necessary in order to foster the change and implementation, hence the interest to be based on this context and in the framework of the legislation. So within the ILO context and the international labor standards, I'm not going to linger too much upon that. They are adopted, revised, and enforced by the governments and by the social partners, the representative of workers and employers organizations. They have an impact on the content of these standards at all levels. So having an impact on migrants, and we're here talking about the main stakeholders. So the ILO constitutions and the international labor standards are particularly pertinent. So the constitution mentions already an interest of the workers in this sense in countries, in different countries. So it is a concern of the organization. There has been a normative revolution that risks to be too detailed. Another principle that is really at the heart of this organization and in the context of migrant workers, it is important to ask ourselves questions. So the international labor standards include in their scope of application migrant workers. And there are some standards that even though they do not belong to that, they do not belong to the specific categories. So in particular, we can refer to the Declaration of 1998 on Fundamental Principles and Rights at Work, 2008 Declaration as updated in 2022, and more recently, the Centenary Declaration. The scope of application of the standards, and in particular the fundamental conventions, are very pertinent. In the framework of other international labor standards, the scope of application will be determined by the instruments. So these standards recognize the sovereign right of states to regulate access to territory and labor market. That is not an opening to nationals. So here you have the set of the fundamental conventions. The latest one date 2022, and the Convention on Forced Labor. This is the number of ratifications of all conventions. So here, you see the general ratifications in this page, in particular cases of SADC, the 16 member states of SADC, And we have the former fundamental conventions on forced labor, on the eradication of child work, of child labor, on equal opportunities and treatment and freedom of association, as well as collective bargaining. All member states of SADC ratified these instruments. To sign conventions, fundamental recent conventions, so the ones you see at the bottom of the table, there are 8 member states that have ratified these conventions. So Convention 155, it is Madagascar, Maurice, Seychelles, South Africa, Zimbabwe, and the second convention that was ratified by Malawi and other states, and to register the, and also in 2022 by Lesotho. So the protocol of the Convention on Forced Labor was ratified by 6 member states of SADC: Comores, Lesotho, Madagascar, Malawi, South Africa, and Zimbabwe. This protocol is particularly important because it shed light on the situation. On the one hand, the definitions, and on the other hand, the extension of measures for social partners, and finally, providing a response to the fact that forced labor, and in particular traffic, was something to be tackled. So the instruments in terms of migrant work, so Convention 97 and the recommendation going with it, and also Convention 143 with its relative Convention 151. This is particularly interesting in case of bilateral agreements. So there is a whole series of instruments that have been adopted in the framework. So instruments belonging to international human rights protection, in particular an international convention on the rights of migrant workers and members of their families. And also, there is a special procedure, a rapporteur on human rights, the rapporteur special. So Convention 97, the historical context is quite peculiar. We have 2 instruments that are complementary. So within this framework, in particular, we refer to regular migration situations. So it is facilitate the mobility of workers, facilitate the circulation of labor. This was particularly an important time for the young people who went to work. So it was right after the Second World War. And the objective is to protect workers. I hear an interference. And it was about protecting workers from discrimination. And we're talking about workers, male workers, who are in regular situations. So this includes migrant workers and families. And there are particularly excluded categories, so like seafarers, members of liberal professions and artists entering on a short-term basis. So the situation related to cooperation between member states, they are treated in particularly with agreements, the conclusion of agreements to regulate migration for employment in cases where numbers of migrants are large. We have mentioned recommendation 86 on temporary migration of workers. So the text of the convention defines So what is this definition? Who is protected? A migrant for employment, who is a person who migrates from one country to another with a view to being employed otherwise than on its own account. The protection provided for in these mechanisms of Convention 97, they can be resumed, they can be summarized this way. So on the one hand, the provision of these regulations providing precise information, and I'm opening a parenthesis, in the case of these two instruments, but in the framework of an instrument providing for that the public employment service is essential. So the fact of providing this kind of information is aimed at facilitating this process and also the service free of charge. These are certain of the measures provided for. In particular, the right to workers to remain in the country. We're going to see more precisely what the mechanisms are. So equality of treatment this is provided for in Article 6. So we have this provision of measures So the equality of treatment means in terms of remuneration and working conditions, affiliation to a trade union and possibility of collective bargaining, accommodation, social security, so it's not the entire set of benefits, situations relating to employment taxes and contributions related to labor, access to justice. There is a whole series of mechanisms, and these mechanisms are quite flexible. So recruitment, placing, and conditions of labor are defined in Annex 1 and 2. In the cases not comprised in the agreements, and Annex 2, in government-sponsored arrangements. And Annex 3, so related to other elements. Convention 143 we have seen in certain examples the arrival of migrant workers in irregular conditions, sometimes in conditions of traffic.
Il s'agit je m'excuse, smuggling of migrants en français, d'un trafic. Donc, dans certains cas, en étant clairement
So in conditions of trafficking, so sometimes
alors que dans d'autres, elles seraient plutôt perçues comme complices.
they are considered as victims, in some other cases not,
L'arrivée dans le pays était voulue
because the arrival in the country, it was desired or it was a transit country. And the legal framework should provide a response to this kind of situations in terms of international negotiations. So the objective is to facilitate and regulate the labor migration flows, to suppress activities of organizers of clandestine movements of migrant workers, and to provide the minimum protection to all migrant workers. So it is a flexible instrument. So the possibility of choosing there is a part concerning migration in abusive conditions and a part considering equality of opportunity and treatment. So who is protected by this instrument? All migrant workers, irrespective of migration status. So we are in a part 1. So we are now in the application of the principles of protection of human rights applicable to everyone and inherent to individuals independently from several factors irrespective of migration status, considering themselves and their families. And there are some exceptions. So part 2 is about regular status migrant workers and their families for remunerated work. There are some exceptions that is considered in part 2. Frontier workers, seafarers, short-term liberal professions and artists, persons coming from training and students and temporary specific duty assignments. So when the concerned people have an employment relationship with enterprises and people posted in third countries. So part 1 aimed at protecting all migrant workers, and particularly we're referring to human rights that are fundamental and that are inherent. So these are the rights contained in the main instruments concerning human rights and also including fundamental rights. So we're talking about the Universal Declaration of Human Rights, the International Pact Economic and Social and Cultural, and the International Convention on Rights of Workers and their families. So this is in order to protect the regular status or loss of employment. So it's distinguished from the right to stay in a country. So their migration status should be not negatively impacted. And in case of migrants in an irregular situation, there is equal treatment there is access to legal proceeding, no cause in case of expulsion, and possibility of regularization. So the examples that are going to be used in a specific case, so the case of Italy, Convention 143, since many cases of SADC ratified the conventions and ratified Convention 97, Malawi, Maurice, Tanzania, and also Zambia, we run the risk of having different cases by the Commission of Experts. So now it's about the comments related to Madagascar, and then we had other. So in the Italian case, the Commission of Experts tackled this situation. So migration and abusive conditions and measures directed at migrant workers, so serious vulnerability of migrant workers in irregular situation toward violation of their basic human rights, challenges of increasing migration flows, rights arising from past employment, access to justice, and need for effective and speedy legal procedures.
L'idée de l'instrument, c'est de lutter contre la migration dans les conditions abusives et lutter contre l'emploi illégal des travailleurs migrants. Cela implique notamment
this is about the obligation to detect, suppress, and prevent irregular migration, and an obligation to prosecute in a criminal way trafficking of migrant workers. And let me remind you that questions linked to migrant workers trafficking for work and employment reasons are part of the 2014 protocol. So, as a member state or as a social partner, you consider the application of such conventions and the implementation of such conventions for the case of migrant workers, you really need to understand the whole profile of ratification of your state, not only in the framework of this convention, but also the already mentioned protocol, which is very much relevant in the case of trafficking of migrant workers. Then part 2, the equality of opportunity and treatment. So repeal discriminatory law and practice. Equality of treatment must be effective and must be promoted, just as equality of opportunity must be promoted in practice. A national equality policy on employment and occupation must be established, such as other policies that are mentioned in the slide. Part 2 of this convention establishes some restrictions on free choice of employment. Such restrictions don't concern geographical mobility within the country, so there are no restrictions about that. So there's also free choice of employment after a maximum period of 2 years. When the migrant worker enters the country, they have presumably a contract and an employer, and such contract has a period and a specific duration. So, talking about this free choice of employment, this can be limited on the basis of the interests of the state. It's not possible, for instance, to have general restrictions and exclusions. There's also another important question when you talk about migrant workers, and especially when we consider SADC region and the initiatives and policies. There's the question of qualifications and the portability of talents and skills. regulation of such matters must take place in the framework of a tripartite negotiations.
So I
No, I'm sorry for
apologize.
that. No, I'm just talking with the interpreters. They are stating that your sound is very low and it's a bit far from the microphone. If you can just speak louder or stay a little bit closer to the microphone. Thank you so much.
Thank you. Sorry for that. Alors, je vais essayer de crier.
I will try to speak louder.
Alors, comme j'ai pris un peu trop mes aises en termes de temps,
So
je vous propose de passer
we spent much time on the first slide, so I would like to go to the highlights of this presentation. So we'll see these two instruments and consider why they are so important.
Forcément, j'ai sauté une des diapos. Voilà. Ces instruments, en comparaison avec d'autres,
compared to other instruments, you've seen the ratifications of fundamental conventions and the protocol. So you can see that compared to such fundamental conventions, these instruments are less ratified. And Convention 97 is more ratified. It's about irregular migration. Whereas Convention 143 is even less ratified. But why are they important? First of all, the fact of having a partial ratification of conventions, meaning by that only ratifying some conventions and not all the relevant conventions, is not very effective per se, because you don't cover the whole spectrum of the regulation of work and labor migration, which is complex, which is diverse and very articulated. There are many gaps that must be considered in an integral way. This is why it's important to ratify all the instruments that were negotiated and adopted by the tripartite constituents. There are questions such as wages that can be covered and that are covered by other conventions like the one on minimum wage. But there are also questions concerning working hours, OSH, or the skill mismatch. So there are many aspects that are directly linked to labor migration and are treated, let's say, and in a coherent way only by the whole corpus, the whole body of such instruments that must be ratified. But why are there so few ratifications? First of all, because of the misconceptions about the requirements and the principles of the convention and the object of the convention. Such instruments are important, they matter. Why? Because of the flexibility they have. There's the chance and possibility to ratify in whole or in part. And then you also have the sovereign right to decide about your migration policy. But it's also a question of validity. They recognize labor market needs, specific labor market needs. They also address labor shortages. No country in the world can say that they have the talent they need in the framework of their country. All countries in the world need labor migration. So it's important to address such labor shortages. They are very important because they combat discrimination. We don't have time to go into the details of this. but they also promote equality of treatment with nationals.
Sustainable enterprises.
You also have to consider the question of sustainable enterprises and the relevance of these instruments in the framework also of the productivity and the chance they have and they give us to enhance economic productivity and avoid social dumping and unfair competition. Such instruments matter and they are relevant because they respond to a reality and they better economic productivity, as I said. And so they are relevant for all these reasons, which are especially important to employers and all the other actors too. What's the scope of such instruments? It's really interesting because it's the people who have migrated or will migrate for reasons of work, all sectors, but also permanent migrants, temporary migrants, seasonal migrants, but also refugees and displaced people. What's the way forward? Next slide. So, you know that social dialogue is always the solution when you work and you attend conferences and trainings within the ILO. So yes, the way forward is social dialogue, but also human rights and the need of an enhanced cooperation by member states. There is no member state in the world that is not either an origin country or a destination country or a transit country. The majority of all the states in the world are more than one. So we need to consider the integral role of social partners. It's important and it is necessary to discuss about the adoption of multifaceted policies promoting equality. We also need bilateral and international cooperation, especially between countries of origin and countries of destination. We need to ensure fair recruitment of migrant workers. In line with Convention 181 on private employment agencies, with many implications on the promotion of employment and follow-up and also control. We also have effective protection of human rights and standards and the effective enforcement of rights and the access to justice. Also, particular measures for certain categories of migrant workers. So, when you don't have statistical data, it's difficult to know the way forward. So one last point is statistical data. We need statistical data to take the adequate and appropriate measures. Talking about the complementary ILO frameworks on labor migration, you have the ILO Multilateral Framework on Labor Migration 2016. You also have the ILO General Principles and Operational Guidelines for Fair Recruitment and definition of recruitment fees and related costs and the guiding principles on access for refugees and other forcibly displaced people to the labor market. Since you are part of the SADC, I would like to remind you that there is a publication which is very interesting that was published last year in the framework of the SAM project on domestic migrant workers in your region. I stop here and I will leave you with one quote by our DG, access to decent work is a key strategy to realize migrants' development potential and contribution to society. We must recognize that injustices suffered by migrant workers are injustices to all. We must do better. So thank you very much, and I'm sorry for the quality of my sound. And sorry for being a little bit too long.
Sorry, thank you very much, Amanda, for the presentation. Obviously, if there are some questions, this is now the time for you to take the floor, asking your questions to Amanda. She can answer both in English and in French. I just will maybe, with regard of the presentation, Amanda highlighting certain of the points. I think what we see with the presentation is first that obviously there are some specific instruments there to protect migrant workers. We see as well that these two instruments were adopted into a very specific moment. I think 97 and 143 have this kind of particularity to have been adopted, taking into consideration historical and economical very strong context. The first one being the end of Second World War. Then we have seen that at that moment, that was very much about facilitating the movement of workers and ensuring that migrant workers were protected and it was very much about the equality of treatment between national workers and migrant workers. The second one was a kind of a different context, because we have seen that there was more and more how can I say, irregular movement, and unscrupulous as well movement, or trafficking and smuggling movement happening. And then there was actually, as I would say, first, the idea of that actually facilitating irregular migration for unscrupulous recruiters, traffickers. It was actually a way of making quite a lot of money. And it was very much about, obviously, stopping that movement, but at the same time protecting the migrant workers in irregular situation that were seen as victims and not as criminals or as part of this criminality. Having said that, there was a lot of and there's still today discussion saying, well, but these instruments, they are quite old now, 49, 75. It seems like a kind of another part of the history. But yet, and I think this is what we see also by the fact that there are some new countries ratifying that. Many of the elements are still very up to date, and many of the challenges or the problems, this instrument trying in a way to address are still very relevant, and maybe more than ever. There is no situation today where we can talk, unfortunately, of equality of treatment between migrant workers and national workers. Till today, migrant workers have, in particular in irregular situation, has been seen are victims of smuggling and trafficking and forced labor very often. So my point is, how do you think, I would say maybe in the coming decade, if I'm just looking in the coming decade, and in the regions, let's also focus on the regions, because there are some kind of also study there, which is done lately on this specific instrument. How do you think the possibility to ratification? How do you think this instrument are relevant for the regions? And if not, what could be the kind of alternative?
Thank you, Miriam, for the question. And I don't know if the sound is good, but I mean, at this point I'm screaming, and because I have a very bad throat, I could lose my voice very easily. So these instruments are still pertinent. And one of the beautiful things about the organization is that if the constituency of the ILO were to decide that they were no longer pertinent, they have the power and the mandate to actually revise them so that they can become pertinent in view of the most recent developments. Those instruments are considered to be up to date. It means that they are providing an adequate response to the needs of the world of work. But as a standard specialist, I would be lying if I was saying, okay, the law ratification records are not something to be worried about. For the reasons that I explained, it means that situations that should be addressed from the perspective of migrant workers, but also from the perspective of the interests of the states and that of employers and workers, are not and are simply addressed in a very in a very silo manner, so to speak. So what happens when the member states have not ratified this convention? But more importantly, what happens when you find that the response provided is not necessarily specific either to your sector, your subsector, or a specific category of workers? And there is the possibility to go via what is known as corporate social responsibility, and to adapt certain type of voluntary frameworks that they need to be used as supplementary to hardcore law, so to speak. Those type of soft law sources are very interesting and pertinent when they are associated with legal frameworks and policies. So they are not supposed to replace existing legal frameworks, but they can be very interesting because as we have seen when we mention certain sectors, the needs of sectors such as the manufacturing sector, the needs of the employers, for instance, of domestic work, particularly migrant domestic work, are not going to be the same as, for instance, the mining industry. So those type of agreements that are voluntary and employer-based may be interesting when they are discussed with the view to being more pertinent to either a given sector or a given category of workers. For a very simple reason, which is a truism. You do not have the same needs and you do not employ migrant workers in the same manner, depending on the sector we're talking about, the country we're talking about, and the characteristics of the workers.
Thank you, Amanda. We have questions in the chat. I would, so what makes a migrant to be irregular? How to interact with Immigration Act of a country? So, if I may, I can just answer potentially to the first part on what is making a migrant in an irregular situation. I think what is quite interesting with is that you have different way of, if I might say, becoming an irregular migrant. Potentially you arrived regularly in the country for instance, temporary periods for work, and you overstay, and therefore ending up in irregularity because at the end of your work permit, you overstay in the country and continue potentially to work irregularly. So that's happening quite often, and particularly for migrant workers in seasonal work that just at the end of the contract overstay in the country and stay in the country. So that is a way of being an irregular migrant workers. Second way is you arrive it, for instance, with a visa tourism or student tourist, and then decided again at the end of your visa to just overstay and just not returning in your country. And that's a second way also of becoming an irregular migrant, and then continue staying in the country regularly. And the last one is obviously when you pass borders without the necessary document for, and then you are from the beginning irregular migrant. What I think is very, with regard of irregular migrant, very often we put the emphasis of the migrant workers crossing irregularly a country, but depending obviously the regions, so that is also something to consider. Many migrant workers actually who end up in irregular situation actually enter regularly in the country, and for different reasons were not or able to extend their work permit or their stay permit, or just didn't achieve to turn, for instance, their student permit into an employment or a work permit, but find it potentially some way of staying in the country. What we see, and then Amanda, I'll let you obviously complement, and this is something we will see in Joanne's book, and particularly in the aspect related to coherence. The problem is that very often migration policy are not necessarily talking with employment or labor policy. And therefore, you have one authorities, most of the time Home Affairs, Interior Affairs, providing stay permits. So the one deciding who is entering and how is entering and providing the resident and the stay permit. And another ministries, which is more in charge of the labor policy, that knows what are the needs of the labor market. And they are not necessarily, these two institutions, these two policies are not necessarily talking to each other. So you're ending up very often with the needs in your labor market, but at the same time, it's not necessarily the possibility to for migrant workers to enter regularly or to stay regularly in the country for fitting, in a way, the needs of the labor market. So that is this kind of incoherence between two policies that might lead to even, I would say, more irregularity or more irregular migrant. On another way, when you have a big the informal sector is quite important. It's also a niche for obviously migrant workers in an irregular situation to find a job, because there is an informality as such. So the more you have, in a way, also informality, the more for irregular migrant workers, it's a way to find a way of living, because jobs as such are already informal. So that's are two of the angles, that we need to look in. First, obviously, the importance of the informality, but also the way your migration policy is not necessarily in line with your labor policy, and vice versa, which lead also for more irregularity. Having said that, and I think what the international instrument is saying is that even migrant workers in an irregular situation has basic human rights and labor rights that need to be respected, independently of the statute as a human being and as a workers. And Amanda, if you want, I'll let you obviously complement.
Thank you. And thank you for the question, because it's really at the heart of the subject matter. When we're talking about the Immigration Act, what Miriam indicated is that very often it falls within the purview of a very different ministry. And when we're talking about immigration, what we're talking about really is the state, the security of the state. So we may find ourselves in front of a very different prism or manner or a way of dealing with immigration. From the employment perspective, once again, a truism, migrant workers are not equal among themselves. There are migrant workers that are going to be perceived as saving and really contributing to the country because there is a gap in terms of offer, and the country needs them. And there are migrant workers that are going to be perceived as competition to national workers, whether it is real or imaginary, right? I always remember an example that was given in Europe. No, it was actually given in the US. So I'm going to take you to my continent for 5 minutes. And basically what they were saying is, it just describes accurately the situation in most of our countries. The fact that you cannot be a migrant worker and benefit from social security benefits if you cannot, on the one hand, be a migrant worker that is stealing jobs, and at the same time, a migrant worker that is benefiting from unemployment benefits. And that is true. Because we're talking about the security of the state, and we're also talking about something that is very personal to us as well. Because depending on the countries where we're from, the issue of migration can be perceived in a very different manner. There is a need to include more stakeholders than we would normally, I would dare to venture. Because when you're looking at a national employment policy, you know who your stakeholders are. But in the issue of migration, there are a lot of myths that need to be busted by people in general, by possible employers, by also workers' organizations. Because depending on the circumstances of a given country, your traditional allies won't be allies at all. Another thing that is absolutely key is, once again, I keep focusing on statistics. We need to know what it is that we have and that we don't have. You cannot enter into negotiation towards a coherent and sound labor migration policy if you're not inviting the institutions that are behind the supervision and application of the Immigration Act, for instance, but you cannot enter negotiations if you don't know what it is in terms of talent that you need, that you actually need, what it is that you're foreseeing for the next 10 years in terms of employment creation and therefore talent needs, and what it is that you have plenty of. And very often, those that should be in a position to give us that type of information either will not give it because it's security, it's classified information. So you don't have, the normal way in which social dialogue operates, dealing in good faith, sharing information is very limited in the context of immigration discussions because everything is linked to state security. So we need to involve more stakeholders, and this is a reality for every single ILO convention, because instruments in the ILO will assume that the state is granitic, in the sense that it doesn't matter whether you have one single ministry in the entire country or whether you have 30, the response that you're supposed to give is exactly the same in both cases. So it's also a governance exercise. And I am going to make the link with public employment policy, with the national employment policies. When you have a national employment policy in place, or a strategy, or however you want to put it, this should consider those type of aspects. It should consider small and medium-sized enterprises, because depending on the size of the enterprises, you may have a very different perspective when it comes to migrant workers, when it comes to the needs. And you need to take into account a number of elements. So one of the links that is not typically made is the fact that national employment policies are absolutely key when we're discussing those aspects, because they require the obtention of information that is also needed when we're talking about migration policies and about equality of treatment and non-discrimination policies. But yes, your question was absolutely to the point. That is one of the major challenges that we're seeing regardless of the continents.
Thank you, Amanda. I'm just asking if there are any other questions for the participants, and maybe I also want to ask to the participants, when we think about the numbers of ratification of this instrument, we see that so one is 57 and the other one is 29. Very little actually African country ratify both convention. The first one, 97, is actually more ratified by European countries, which we can understand, taking into consideration again the historical context. But I think, you know, they are still very relevant for as well, particularly African countries where they potentially have important representation of their national in European countries. And what is quite important as well to say with regard of the the monitoring process of this instrument, if there is, and then Amanda, I will let you explain better, but the complaint mechanism is not open for those who didn't, a country who didn't ratify this instrument. So in a way, if you didn't accept yourself the rule of the game, you cannot complain that some countries which ratify this instrument didn't do not apply them. So you're accepting the rules of the game, and then once you're accepting the rules of the game, potentially there is a way for you to make a complaint, whether you are trade unions, employers, or potentially. But then Amanda, you are the specialist on that, even government from one of the countries. So we see that there is still it can be interesting for countries that are country of origin to ratify as well this instrument. And if we think about, for instance, the case of Philippines ratify all instruments that are protecting migrant workers. Because very often we say, well, if you want to make a very particular case for the protection of migrant workers or to your nationals, you have in a way also to show that you're accepting the rules of the instrument protecting them. And that is a way, a bit the strategy as well taken by the Philippines. They ratify all instruments that protect migrant workers, and some specific instrument as well, like this, the 197, 189, with the case of domestic works, which also make Philippines, you know, quite a leader, if I can put in terms of country, when we talk about at the international level the right of migrant workers. So the point is, you know, what do you think is making difficult potentially or challenging ratification of this instrument in countries where the protection, particularly when in the case of country of origin of your national abroad, is sometimes quite challenging in certain region or in certain other countries. So I'm asking you the questions to you, Amanda. I'm also asking the questions to the participants. What do you think it would take for more African countries or Southern African countries or countries from the Indian Ocean regions to ratify this instrument if needed? And I see as well that we have Didier from the République démocratique du Congo, who raised your hand. Abel, Didier, you have the floor. Vous avez la parole. Je ne sais pas si vous m'entendez.
I don't know whether you can hear me. I see that you put on your microphone, you can speak.
On vous entend pas, par contre.
We cannot hear you.
Vous avez peut-être un problème de micro.
You have maybe an audio problem with your microphone. I also see that we have Conti who raised his hand. Let's see whether Abel in the meanwhile is able to solve this audio problem, and Conti, you have the floor.
Much, madam.
Hey, I hear you well.
Oh, thank you so much. I just want to present a crisis that we are having in South Africa in terms of since I've learned or learning about right-based approach, you know, the ILO standard in terms of ratification and implementation becomes a challenge. We haven't ratified these conventions for so many reasons that I can list and debate for a year. We, you know, we develop policies, and as we start with this policy, we've got a crisis of migration, labor migration. Then we try to focus on the labor migration, and then we have a problem of not ratifying conventions. And the next thing, you want to link the policies. For instance, the Madam has just mentioned the issue of national employment policy. I mean, when you consult with any other stakeholder, you find that there are gaps between one policy to the other. You have public employment services, which it's like an old document, which is linked to Immigration Act, and the act it's not yet amended, and there are things that you can amend in the Immigration Act because of the UN declarations and so on. So some of the things, when you develop labor migration policy, it comes bit by bit, and it brings a lot of confusion, and it brings frustrations, and it delays the process of having a final document, since we can't, some of these conventions or this recommendation, we can't even ratify the 97, the 143, because of that situation of not amending an Immigration Act. Not forgetting that we have a problem or a crisis of the flow of migrant. You know, it may be refugees, you may regard them as refugees or whatever, job seekers or whatever status of a person. But while we are busy with these, you know, documents, it really brings us into a status where we can't even control our country itself. So I think some of these things we need to address it properly, to make sure that these policies are aligned. If the UN could allow countries to amend the Immigration Act, where they state if a foreigner is a foreigner, if the status of a person is irregular, it must stay as irregular, and the person must move freely. So let it be clearly stated to all the countries. One country mustn't just receive, whereas other countries cannot receive. You know, it brings too much of biasness and political, I don't know how to state this, but it's too much of politics. And every country, when I look at it, especially in a country that is not wanting to receive people, they don't have a vision. They don't have a vision. They don't have a clear mandate. They don't have a clear insight of how migrant workers are struggling or are frustrated when it comes to issues of if I refer to those recommendations and protection of some sort, for instance, equality of treatment. So I just want to raise those issues, because I'm telling you, I'm one of the person who's developing this policy, labor migration policy. We are still stuck with amending other acts that will be interacted or recommended as you know, a linkages, and it's a serious matter that needs to be taken into consideration. Thank you so much, Miriam.
Thank you very much, Conti, for sharing your concern, and I think it's very well understood. And I think you said, you know, something which again will make echo to certain other session that will happen in the face-to-face phase, and particularly with regard of the development of a policy. You will hear from different colleagues, experts. I'm thinking very much about, for instance, the inputs that will be provided by Vincent Williams. You just mentioned the questions related to vision. And I think this is, in fact, the first goal, you know, while developing a labor migration policy is what's the vision? What is your vision for this policy? What do you want to, you know, to reach with that specific policy? And sometimes indeed the question of vision is not necessarily that present or unclear as well, because it's touching so different area or so different institution, actors, stakeholders that need to be involved and to be engaged in the policy. And sometimes this kind of, again, rights-based approach is a little bit left aside. Well, it's not about, you know, also because potentially the fears of, oh, if I'm bringing, you know, a rights-based approach, then what the people will say is, I want to give more rights to migrants, and that would be very, that won't be necessarily understood, you know, by a population or the public in general. But it's not about providing more rights than to national. It's not about giving them more advantage that national has. It's just very much about equality of treatment, you know, and ensuring access to the minimum rights they should have, or just equality of treatment and treatment with national workers. I don't know, Amanda, if you might wanted to intervene. And I think we have a last comment from our colleagues from Didier, and then we might stop for the day.
Well, thank you for the comments. I find them very pertinent. And in the case of South Africa, I'm not going to go towards the normal topics that we've been discussing in the case of the country migration dialogues. What I would like to do is to emphasize one aspect that is seldomly mentioned when we're talking about South Africa, which is the main recipient of migrant workers in the SADC region. Let's be clear, it's South Africa and Namibia. South Africa fails to forget that it also generates migrant workers. So when we're talking about policy, and this is why it's so important to be clear that you're either a transit country, a country of origin, and a country of destination, and more likely you're going to be all of them at some point or another in your history, or at some point or another in the history of migrant working. So one of the things that we were discussing in an entirely different context, before I forget South Africa, you've ratified Convention 190 on violence and harassment in the world of work. Please have a look at Article 11, paragraph A of that convention, because it mentions among the policies of interest, those relating to migration. Okay, my parenthesis is closed. So when South Africa, and I'm venturing to say something that I don't entirely know, when South Africa is looking at their migration policy, they're probably looking at themselves as a country of reception, of destination, which is fair, because that's what we all associate South Africa to. But the member state also needs to take into account that there are South African migrant workers going places. There are quite a few in the legal field, among other places in the UK, for instance, and that those migrant workers are flying under the radar. They're not being taken care of. And when we're talking about a labour migration policy, we need to have a comprehensive understanding of who the migrant workers are, those that are coming in because they wanted to come in, those that are coming in on transit, and those that are leaving. Another thing that I would like to mention, particularly in light of the fact that I used to be based in Central Africa, is you need to know who the countries of destinations are. So there is no point in starting negotiations of bilateral agreements with a member state that is not really relevant in terms of migration fluxes. And I'm going to give an example. A country like Cameroon, which has ratified the two conventions, has a number of bilateral agreements that have to do with the portability of social security benefits with a country like France. Ask me where most Cameroonians are going. Nigeria. There is no agreement with Nigeria. So, as indicated, and thank you very much for your intervention and the questions, these aspects have to do with state security, and they're linked to something else, because when we think about South Africa, we also need to take into account the conditions of the labor market in South Africa. So someone from the mining sector may have a completely different point of view than someone from the agricultural sector when it comes to migrant workers, in terms of how much they need them, how much they can do without. And I agree with you, it's a very complex situation. But to be entirely honest, I was very surprised when I saw a NEDLAC document and I saw no objections to the ratifications of Convention 97 and 153. But we need to be honest about this. This is, and I'm not throwing shade on the instruments relating to child labor. Don't take this as the conclusion. But we are not in a circumstance in which we're saying that it's wrong to employ kids that are 5 years old for jobs. We are not in this context. We are in the real world. These issues have a political impact. They have an economic impact. They have clear linkages to state security. They have clear linkages to something as personal as your concept of identity as a person. So this is not going to be an easy matter where you're going to have all stakeholders sitting around a table for 5 minutes and say, oh yeah, this is wrong. And we need to also acknowledge the complexity of this. One of the things that Miriam was aiming to, I'm going to be very naughty, very naughty. If I were to, if the ILO were to sack me tomorrow, and I had to find a job of my own, and I had to give some counseling to either migrant workers or countries of origins, I would just say, let's have a look at the ratification tables of the country involved. The example that Miriam gave regarding to the Philippines is particularly interesting, because if I am an employer organization or a worker organization, I don't have to limit myself to the country where I'm based. So for instance, I could be looking at things and saying, oh, I'm not going to pick on South Africa, let's pick on someone else. Let's pick on, oh, it's funny, I forgot to actually include Mauritius. Let's pick on Mauritius. So I'm going to use my country of origin because like that, the situation is quite ridiculous, but the point is that you need to get the example. So I come from Honduras. Probably last time I was in Mauritius, I was 100% of the Honduran population in Mauritius. But what could happen is that I contact my Honduran trade union federation or even my Honduran employer federation, because I could very well be not necessarily a worker, I can very well be an employer, an investor that is suffering from discrimination. And tell them, okay, I've been mistreated in Mauritius, that violated my rights for this and this and that. The Honduran Trade Union Confederation can submit observations on the non-application by Mauritius of the provisions of Convention 190 regarding me. I gave a very poor example because typically it's it involves more than one person, but there is nothing in the procedures relating to Article 23, Paragraph 2 of the ILO Constitution that limits the observations to the country where the organization is based. In the case of the Philippines, there was a complaint that was lodged concerning migrant workers. Do not ask me which country. And it had to do with migrant workers from the Philippines working elsewhere. And this is very interesting because when you start looking at the situations that we know in the SADC regions and that we've heard about, and you start looking at the member states and what they have ratified I would advise you to look very closely at the member states that have ratified Convention 190 on violence and harassment in the world of work, because it's the world of work, it's not the workplace. And there is a specific mention of migration policies. I would be looking also at the countries that have ratified Convention 189 on domestic work, because there are key provisions that relate on the one hand to private employment agencies, and on the other hand to migrant domestic workers. I've been looking very few countries, only two in SADC, that have ratified the Convention on Private Employment Agencies, and those that have ratified the Protocol on Forced Labor. Because one thing is clear, is if I want to make a ban against the member state, because remember, we're talking in terms of legal implications, but also political and economic. If I want to create a scandal, even if South Africa had ratified Convention 97 and 143, I'm not going to go after South Africa for violation of those conventions. I would go against South Africa for violation of the fundamental rights. So that is where, in terms of what I keep emphasizing in terms of you need to be looking at your ratification profiles, is you need to have a comprehensive approach towards the situation, circumstances, or realities that you want to tackle. So that's why you need to take into account a number of provisions. But in terms of being completely protectionless, I wouldn't dare to go down that route, because there are a number of instruments that do provide people that feel that they've been that the rights have been violated, with possible solutions through ILO special procedures, among others. So a typical thing is, for instance, freedom of association. I'm going to pick on the DRC for a second, apologies. In the DRC, up until very recently, I'm saying up until very recently because I don't know if they've changed the national legislation, a migrant worker could not be eligible to become a trade union leader unless they had spent, I don't remember if it was 20 years in the Democratic Republic of the Congo, and that is considered discriminatory, and that was pointed out through the Convention on the Fundamental Convention 111 on discrimination, employment, and occupation. So, you know, there are different ways of trying to change things, whether legally, policy-wise, or in reality, but they are way more time-consuming, and they are less effective in terms of really acknowledging the complexities of the given situation. Thank you.
Thank you. Thank you very much, Amanda. I just will take maybe the last, I'm conscious about the time, quite late. Didier, je ne sais pas si vous m'entendez maintenant, si vous arrivez peut-être à mettre votre micro. Vous avez votre main levée depuis un moment.
Didier, so you raise your hand. Can you unmute yourself? Can you hear me? We can hear you very well. Hello. Miriam, you already said it all. So did Amanda, talking about the different facets of labor migration, and considering DRC and the extent of our territory, we are a destination country. And we're trying to do our best to move forward in ratifications. And we have recently organized a tripartite dialogue on this matter in July 2022 in order to draft a national policy on labor migration. We worked on this document, and now, unluckily, this document is sitting on the table of politicians who should decide. So it's very slow. We're doing our best, but it's time consuming. There's also a question of discrimination. And it's about 97, Convention 97 and 143 that need to be ratified still. But you see, Miriam, there are many migrant workers that come regularly, but many others come from, let's say, in irregular ways, in containers, in lorries. They come from other neighboring countries. We give them a job in an irregular way. They're not unionized, they're not registered. There's no social security for them. They work really hard. And when you try to approach them, they are afraid that you denounce them and that they can be reported. And we don't know how much they are paid, but we know that they have no coverage, no social security, no health insurance, no protection at all. Even the workplaces are not known, so they are completely exploited. And since you don't know where they are, since they're not unionized, there is no register for them, it's very hard to follow them and to reach out and to reach them in general. So this is my question. Yes, Amanda, it's complex, but as workers, we need to work and to do our best to eradicate this phenomenon and this way of treating people. So how can we do that? At our level, yes, we are at trade union, we denounce, we use our tools, but together with some project, we have drafted a national policy. That's already very good. But what can we do in order for our country to ratify Convention 97, Convention 143, or maybe also Convention 190 for domestic workers that is still sitting in the parliament because it needs to pass through the parliament. But it takes time. I don't know what we can exactly do to protect these unprotected migrant workers that come. They are not registered, as I said. We don't know them. We don't know their profile. We don't know their condition of living. They have no social protection, social security protection. So this is my question. But I also have a recommendation at the regional or sub-regional level. I think that SADC member countries should find agreements among them so that if I am from DRC and I find myself in South Africa and I work in another country of the SADC, I need to ensure the portability of my contributions to my country of origin. Because when I stop working in South Africa and I move back to my country of origin, I will be without contributions. So portability is fundamental. Also because at the sub-regional level, we have no agreement, no regional or sub-regional policy, and this is challenging for migrant workers. So this is what I can say now. I can't give more examples because I don't have much time, but these are some very key elements in my view that are challenging to us, and we don't know what we can do to eradicate this phenomenon, even if we know that together and thanks to some projects we can definitely move forward. Thank you, Didier. Amanda, you can intervene very, very fast. We only have 2 minutes. Thank you for your remark. There are many things to say indeed. In the framework of the SAM project, DRC is part of the countries for which we will go through an analysis and a study in order to pinpoint the gaps, the contradictions in the different provisions. Or the voids or confusions in the framework of the scope of Convention 97 and 143. Eswatini, Lesotho, Zimbabwe too are asked for this kind of detailed study. As worker, you have many things that you can do. There are many things that you can do. On one side, you need to contact the office in Yaoundé for your country. And I know that there are things that you can do as a trade unionist or a trade union leader. The fact of not having migrant workers as a candidate to leadership in the trade unions unless they have 20 years of staying in the country is already something that we can consider. So it's not even about migrant workers in per se, it's a question, it's a more radical question of freedom of association for you, because if I have to choose between a national trade union leader or a person from Burundi who's been living for 5 years in DRC, well, I will probably choose the former. And this is a question of freedom of association. So I don't have free choice. And I've also sent the link in the chat box in French, and I will find the version in English. And the government said that the National Work Council will be involved in the debate on this matter. There are 15 organizations, I think, unions, and there are many actions of promotions and advocacy that you can bring about. You have some scope for flexibility in the SADC region compared to common law countries. And there are many actions that you can carry in the framework of tripartite dialogue. You ratified Convention 144 on tripartite consultations, and this can be a very good point to start on your campaigns for ratifications. It is true that in the SADC region, such employment issues are considered not in a very comprehensive way. And please keep yourself on mute. Thank you. One very last thing. Usually, there are no visas needed in the SADC region. Now, during the last ministerial meeting in DRC, visas were asked and needed. So it's a question of taking the decisions at the sub-regional level and it's important to bring this issue to the table, not only among unions, but also in the framework of tripartite consultations. And this is definitely in line with social dialogue and the health of the institutions, tripartite institutions and social dialogue institutions. Thank you, Amanda. It's 4 o'clock, so the time has come to end our session. Priska?
Priska, I see you had a questions related to social protection. If you don't mind, keep your questions and we will have a specific session on social protection during the face-to-face phase of the course. So there will be a specific elective course on social protection to which we can come back on that specific aspect related to access to social protection for migrant workers. Next session would be Friday, so and it would be on social dialogue. I think we heard already, about role that could be played or changing face by workers' organizations, thanks to the contribution of DDA. But what we want also within the course, and it's also a very strong message of the ILO, is actually a good governance of migration would include the consultation with employers and workers' organization, and should be done through social dialogue. So the role that social dialogue could play for a good governance of migration is quite key, and we will discuss about that Friday with two of my colleagues, both specialists on social dialogue in Pretoria and in Turin. So together with them, you can ask them more any questions related to the role that could be played by social dialogue. So they don't necessarily have a migration background, but they have a very strong social dialogue background. So I think they can give you very interesting example on the role of social dialogue, and indeed how it is quite crucial in the whole consultation process to ensure that key actors of the world of work are included in the development, but as well implementation and monitoring of a labor migration policy. Thank you very much, thank you very much, Amanda, and the interpreters. I know that today the sound was a little bit challenging, and thank you for the effort, Ludwig and Edva, you made to make it happen. And we see each other then Friday for the end of our second week. And then we will also provide you more information about what you can expect during the face-to-face and what would be still to be done before you leaving for Johannesburg. Amanda, as usual, it's a pleasure to share a session with you. And thank you for your time and for all the experience, also the very concrete experience you shared with us today. Hope to see you in Johannesburg. I don't know if you will, I think you are on mission the week 2025, if I'm not mistaken.
I am on mission in Johannesburg for the SADC meeting of the
yeah, true. So maybe we can catch up in Johannesburg. Enjoy your evening, and see you all very soon. And if any questions on the platform, you have Hakim's email. Any questions related to your travel to Johannesburg, please contact Hisham. And good evening to everyone, and see you online Friday. Thank you all. Bye.